day one of Rocky's shooting trial is something you do not want to miss.
Also brought up a nice comparison to what has happened thus far.
Just a minute. Alex, could you please go out and tell the jurors that we're dealing with some logistical matters, and just to please be patient, and we're going to have them come in as soon as possible.
Yes, sir.
Go ahead.
One, as the court is aware, there is no logical reason why either Robert Hamadai's division or the DA's office would have in any way not turned this over. It's very clear that this evidence only helps our case. So again, as the court pointed out, on the one hand, Mr. Takavina says, the client cannot get a fair trial. This is so apparently damaging. Yet on the other hand, he says, hey, it doesn't really matter because it includes so many other guns that it should be kept out as being irrelevant. But what's very clear is, and I didn't appreciate the comment, when Mr. Takavina suggests that he can't believe that the DA's office did not know about this in advance, when I spoke to him on the phone last night, that is not what I heard. What I heard was, hey, listen, this is a problem for us. We understand, I'm going to quote Mr. Siegel, there's no reason why you would have not turned this over if you had it, which is correct, and the record would support it. Comparing this, counsel is now discussing and saying how they are being victimized by late discovery. The only late discovery in this case, and the court's aware of it, the court ordered that the discovery be turned over on 2 witnesses. It should have been turned over before the court ordered it.
I don't want to deal with something that we've already dealt with.
Okay.
I understand about the 2 defense witnesses.
Okay.
We've covered that.
Right.
Just deal with the present issue.
So, what counsel did is, he cited last night, he sent to the court a case called Hughes, 2020 case, 50 cal at 5th at 257. He included no facts about that case. At 2 in the morning, I went and I read the case, and I then sent an email. That case, so the record is clear, involved a situation where there was a Watson murder, and where the defendant was being tried on a theory that his alcohol intoxication had caused the accident. The investigation had been done by the MATE team, and they had determined that in fact it was speed and not alcohol. This was a very huge problem for the prosecutor. At the very least, and as the Court of Appeals said, the prosecutor was given information that in fact the MATE lead detective now had a new opinion contradicting the prior opinion that in fact, in actuality, it was caused by alcohol and not by speed. Instead of turning this over to the defense, the prosecutor literally had the witness on the stand in front of the jury. He then pauses, looks over at the defense and says, hey, by the way, here's the diagrams and here's the information that he's going to be testifying to. Defense is obviously horrified because it's the entire case. The defense asked for a mistrial. They asked for a continuance. They were both overruled. The Court of Appeals said, hey, listen, obviously the suppression of evidence, as the court is aware and under the statute, is the last option a court can utilize, only after every other option has been determined to be not harsh enough or not accurate enough in addressing and solving the situation. The Court of Appeals said, hey, listen, Judge, you had a chance to do less remedy. You didn't do it. The jury ended up convicting, and the case was reversed. To compare that case to the facts of this case, it is distinguishable for the following. Number one, that evidence was not just inculpatory, it was the entire case. Number two, the prosecutor, for a tactical advantage, which the Court of Appeal basically said in a footnote, that although the original trial judge had found no prosecutorial misconduct, that in essence the record didn't support it. meaning that there was misconduct that the prosecutor knew. The prosecutor decided, for a tactical advantage, that he was not going to turn it over. He then did it while the witness was on the stand. He then opposed any continuance or mistrial. Here's what we have. We have evidence, which it is inculpatory. It's inculpatory because the defendant is found at his location, at his house. There is a 9mm magazine for a Glock 43, and there's no Glock 43 to go with it. So it's just a magazine. We already knew that the defendant had the Glock 43 magazine, and we knew that these were 9mm casings. The difference now is that there is going to be evidence that suggests that a Glock 43 is more likely to have put the marks on the expended casings than many other firearms. So the idea that this would be excluded under 352 is patently absurd. The idea that Hughes is in any way authority for what they're asking is also absurd. We talked to the lab this morning. First, what we are proposing is that we will not mention this evidence in this case in opening. We will wait and see how the case develops. As the court is aware, and the court is aware of this from the discovery of the witnesses that we got the day before we started trial, the defense is now claiming not only that it was a starter pistol, but they are claiming that the 9mm magazine, which was found at the defendant's residence, actually belonged to the defendant's manager, and that he is going to testify. So let's look at how this plays out. If the defense ends up being that, in fact, this 9mm magazine belongs to the manager, that in fact what was used at the scene was a starter pistol / prop gun, then although we don't believe that's credible evidence, that is where they're going. So here's what we're asking. One, there's no late discovery instruction because, as the court is aware, and maybe counsel is not, to have a late discovery instruction, the court has to find that we had the information and didn't turn it over. There's no reason why we wouldn't have turned it over, and as soon as we had it, we turned it over. And as the court's aware, I've been trying cases in front of His Honor for going on 30 years. As soon as we found this evidence, we contacted the court and we contacted counsel. Number two, the lab has told us that basically what they did in this case, to have someone else examine it is a very quick examination, and the amount of time that it should take for someone to examine it and end up being able to assess whether or not LAPD was accurate in what they found is ranging from a few hours to maybe a day. This is what we would propose. We would propose that at this point in time, we will not mention this in opening statement. We will see how the case develops. We will, if we believe that this is evidence that is going to be important, we will ask to admit that evidence later on in the trial. In the meantime, we will make arrangements for counsel, and they can hire any qualified firearms expert. I want to distinguish between Hughes and this case. Hughes was an extremely complicated accident reconstruction involving a vehicle where multiple individuals died. It was very time consuming. It's an extremely complex investigation. This is very minor and simple ballistics interpretation. So we will make it available. We already have sent our investigators to recover the evidence. I don't know if they already have it. We believe they already have the evidence. They have it with them. And we will get it to the defense. This is related to the other issues, so I just want to make sure that this is clear. Counsel seems to be under the impression that the court has now changed its ruling and that we are not allowed in our opening statement to address the idea, which the court previously ruled we could, that we did not find out about this defense until the 20th. The court had said previously, on the record, yes, Mr. Lewin, you guys can address that issue in opening. I will decide whether I'm going to issue a discovery instruction later. Counsel believes you've now said we can't do that.
I did say that.
Yes, they did. Yeah,
I
pretty
did.
clearly.
I had said yesterday that the purpose for an opening statement is to give the jury an idea of what the evidence, what you believe the evidence will show. Talking about late discovery, that's argument. So as far as your opening statement, I don't want you to mention anything about you just found out about a starter pistol. That is not part of what the evidence will disclose. I talked about that yesterday.
So, but I am correct. The court's original ruling was...
Yeah, that is what I said. Originally, I said, yes, you can bring it up.
Okay.
But then after thinking about it, that's not part of an opening statement. So I don't want you touching it.
Okay, understood.
Go on with the present issue about the ballistic.
So where we sit right now is that counsel is arguing two inconsistent positions. They're arguing that this evidence is so damaging that we have to start over. Now, that's not in a vacuum. It's very clear that the defense is not happy with this jury. They've made it clear.
Hold on.
No, don't interrupt.
Okay.
He didn't interrupt you, don't interrupt him.
It is very clear by the comments the defense has made in court, where they have repeatedly said that their client is not getting a fair trial because of what they believe is the composition of the jury, the fact that they have filed a writ, the fact that they have continued to bring this up, leads to the inescapable conclusion that what they are looking for is a way to start over. I believe, Your Honor, that what we have proposed is more than fair, because in the end, Your Honor, they're arguing it both ways. As the court mentioned before I ever pointed out, they're arguing, if you let this in, Judge, my client can't get a fair trial. Oh, by the way, what's the value of this anyway? What does it matter? Again, my position would be the second argument is inaccurate. It is evidence that is helpful to our case. It doesn't prove the case by itself, but it is definitely helpful. It is not irrelevant. It's not related to.
All right, you don't have to go on.
Okay.
I believe I have enough information to make a decision.
All right, you've heard this on.
No, you can't.
I can respond to what he just said about the jury.
It doesn't matter about what he said about the jury. That has
No, it
no,
doesn't.
stop.
Come on.
That has no bearing on any decision I'm going to make.
There's a record, though. There was a record. Okay, put place on the
I don't believe that you are unhappy with the jury.
I'm
Mr.
not.
Lewin might say you're unhappy with the jury, but that's not, I don't believe you are. If you were, you wouldn't have accepted the jury. I believe that both sides are satisfied that with this jury and that both sides will get a fair trial. You don't need to respond to it because it doesn't matter whether he does or does not think you're happy with the jury. I believe that you're satisfied with the jury. All right, here's the way I want to deal with the latest, recently finding out about this ballistic report. Everybody at the table, all counsel, to me, has great credibility. I accept what all of you say. I don't believe that there's been any nefarious conduct by anybody. If this late report involved, all of a sudden that it was disclosed that a witness, an additional witness positively identified Mr. Mayers as the shooter, that would be very critical and crucial. If a witness came forward and said, yeah, Mr. Mayers confessed to me that he shot asaprocky, that would be very critical and crucial. If a firearm, if a 9mm was recovered, the thing here is that the casings that were recovered were examined, and the opinion is they could have been fired from a Glock 43 or any other number of types of 9mm. You have said that, well, now you want to hire a ballistic expert. That's not fair to you and your client. So this is what I am proposing. We have a list, a Superior Court list of firearm examiners that have been recognized as experts. My star judicial assistant over there, Alice, will print out that list. Ms. Kaplan is an attorney who practices in this area. If there is someone on the list that you want to hire, contact that person and tell them this is crucial that the ballistic evidence be examined now, not later, but now. The court will pay for it. Mr. Mayers will not have to pay for this. We will. If the firearms examiner wants extra money because it's a rush, the court will pay for it. If you are not satisfied with the people on the list, then if you want to find your own examiner who will do the examination, the court will pay for it. If it's necessary that I speak to the examiner to impress upon the examiner the importance of getting this done ASAP, I'm glad to do that. I am providing my cell phone number to all of you. If you need to call me any time of the day or night, I will speak to you. I will speak to a firearms examiner. If you feel it is necessary, Mr. Tacopina, we can be dark on Monday. But I'm not excluding the evidence. I don't find that there is any nefarious conduct. The evidence is relevant. It's not a smoking gun, but it is somewhat inculpatory. But in and of itself does not mean that your client is guilty. That's the way we're going to deal with this, and that's the final ruling. I don't want to hear anything more about it. That's the end of the issue for now. Are both sides ready for the jury to come in? Do not mention anything about the ballistic comparison in the opening statement.
That was our question.
So,
Yeah, do not mention that.
Understood.
Your Honor, what I was planning on mentioning was that the cartridges found at scene were 9mm. In the defendant's house was a magazine that was 9mm.
All right.
And had some 9mm live ammunition in it. That was it.
If that has been part of the discovery and that was known, then that's fair game.
Yes.
But this ballistic comparison, that's off limits
Correct.
for the opening statement.
Yes.
Understood.
All right, bring the jury.
Bring the jury and I'll print the list for the.
Oh, yeah, do you want that, Ms. Kaplan?